We're studying the Tractate Makkot, and we are on page 6b, in the middle of the page, and we're talking about rules of testimony and witnesses, and we have some just a beginning of a. It's a subject we mentioned last time as well. And it pertains to two witnesses that saw the same event from two different angles, point of view, and they did not see each other. We know that in Jewish law, witnesses are come as a set, as a pair, at least a pair of two, and they need to be together. They need to they need to see each other. They need to know of each other. They need to come as a set, and they need to see exactly the same thing, ideally from the same vantage point. So Amar Rava, and there are obviously variations of it. What if one of the variations is in front of it? What? אם היו רואים את המטרה או המטרה רואה אותם מצטרפים. So there is a law which again we mentioned last time as well. And that law has to do with the fact that for capital punishment, the accused, the person who is committing the crime, before he can be punished by death, there are several conditions that has to be met. One of them, he needs to be warned. Please, you're not allowed to do this. You should stop. Don't do avodah zarah. Don't idol worship. Don't mechal Shabbos. Don't kill. Whatever that is, that the sin that we're talking about that brings capital punishment. He needs to be warned. Now we know that the two witnesses need to see each other in order to become a pair. In order to become a unit, they need to be aware of each other. So Rava is extending it and saying, what if? Now, before Rava, now the person who is warning, presumably, is in earshot of the person who's about to commit the crime. So he's right there, and he can talk to the person who is about to commit a crime and tell him, "Listen, don't do the crime." So he's very close to the actual person in most cases. What happens if the two witnesses are seeing the person who is warning the criminal? The one who is about to commit the crime. So the two witnesses from two vantage points are seeing that person who is performing the warning, or the person who is doing the warning, who is giving the warning, is seeing them, both witnesses. He looks to the right to see one witness, he looks to the left to see another witness, or they're in two floors in the same house, so they cannot see each other because one above each other. But the person who is warning is seeing both. So Rava says that it's considered that he is uniting them, because he is part of the apparatus that is dealing with the crime. He is not the witness, but he is the person who is giving the warning. So he's part of that scene. He has the ability to unite those two witnesses and make them one unit. And we know what's the advantage or what's the implications of those two witnesses having being one unit, that if one of them is invalid because he's a relative or is unreliable or whatever, is not a kosher witness, it automatically invalidates the other one as well because they're one unit. And similarly, if one of them was caught in a lie, that he was in Florida at the time and wasn't around, and he's just saying that he was around, because came to court as one unit with the other guy also cannot be accepted. But in that case, when one of them is becoming a conspiring witness and the other one is not, the conspiring witness is not dying because there is one part of the unit which is not the conspiring witness, so he's saving him. So the fact that they're becoming one unit, sometimes it's helping the bad guy, sometimes he's not. So, but in any event, they're becoming one unit. Rava also, while we are talking about someone who's warning the person who's committing a crime, so Rava also says that the warning can come from anyone, meaning it can even come from the person himself. The person owns mouth can say, the murderer owns mouth. Some say it's the murderer, some say it's the person who's about to get to die. He's telling him, don't kill, you're not allowed to kill. That's a warning that he gave him, and then he died. So some say it's the murderer owns mouth, and someone says is the victim owns mouth. But in any event, someone who's really part of the crime is able to also perform the warning right before the crime. And afilo mipi shed. Now shed is called a ghost, a demon, whatever. It's a saying in the Gemara that even if the voice is coming from, I don't know, from undisclosed locations, from anyone, as long as the voice is heard and the warning is provided, the person who is providing the warning does not have any condition as to what he needs to be. Witnesses need to have certain conditions. They need to be kosher witnesses. There are a lot of conditions as to what's acceptable and what's not. But the person who's providing the warning, who's delivering the warning, does not have any qualifications. He can be even a demon, a ghost, anybody, a fleeting something. Just don't do it. You're not allowed to do it. It's somebody with a bicycles pass by. You don't know who, what, where, when. It's a legitimate warning. All right? All right. Now, Amar Rav Nachman. Rav Nachman is bringing another rule here, another law, and it's related to a disjointed testimony, edut meyuchedet, disjointed testimony. What is disjointed testimony? Those are two witnesses that saw the same event, but individually from two angles. They didn't know of each other, they didn't see each other, and they are not showing up to court as a pair. They're showing up to court as individuals. So this kind of a testimony, we know, is not allowed when you're talking about capital punishments, because there are very strict laws as to what's acceptable, and we are trying always to find reasons to get them, for the court not to impose a capital punishment. So we are very, very strict in the rules, and therefore not a lot of people make it to the gallows, so to speak, because they're being acquitted for all variety of reasons. A lot of them has to do with the quality or the qualification of the witnesses. So, however, if we have a monetary transaction, a case of monetary law, monetary transaction, a loan, and two people saw the loan, one was on the first floor and one was in the, on the second floor, and they saw the same thing, but they didn't see each other. Rav Nachman says that it's okay, it's kosher. In monetary law, it's kosher, because in monetary law, we are not as careful or not as strict as to the exact quality of the witnesses to that extent that they need to see each other. And he's bringing a verse that says, "Dichtiv lo yumat al pi ed echad." That when we're describing a capital punishment and how a capital punishment crime needs two witnesses, we're saying specifically that the accused is not going to die based on one witness, which means only when you're talking about capital punishment, when there is death involved. Okay, but when you're talking about monetary transaction, when it's only about a monetary money moving hands, it's okay to have a disjointed witnesses. We still need two, but if if each one comes on its own, is okay according to Rav Nachman. So בדיני נפשות הוא דיין כשרה, אבל בדיני מנות היא כשרה. So that's how he learns it. So Rav Zutra disagrees with it, and he's asking an interesting question. Matkifla Rav Zutra. Rav Zutra objects to this and says, "Ela me'ata b'dinei nefashot tatzil." What he's saying is as follows: we know that we are trying as hard as possible to get someone who is about to be punished by death off the hook, off the death penalty. We don't want to kill. So what happens if this kind of a testimony causing the person to get off the hook? It's also dinei nefashot, it's also laws of capital punishment. Do you accept it in case it's helping the person who's being accused, or because it's capital punishment, you don't take disjointed testimony altogether? So alamat nan hu ve'neragim, and he's bringing Rav Zutra is bringing a proof from our Mishnah that it's so, that is the case. What's our Mishnah saying? Our Mishnah is saying is that if you have two witnesses, two sets of witnesses, and you have two sets of witnesses, and they saw the same crime, and one set became conspiring witnesses, so they're being killed. But there is another set of witnesses that saw the actual crime, and so they're convicting the person. So the person who was standing on trial is being convicted and killed, and one set of witnesses are being killed as well. And this, according to Rav Zutra, is basically also a disjointed testimony, because it's two sets, but they're disjointed, and nonetheless we don't get the person who's accused off the hook. And from that, Rav Zutra is ascertaining that the same law is when you have two individual witnesses who are seeing it in a disjointed way. And so he says that according to Rav Nachman, it doesn't sound to jive with our Mishnah, and the Gemara is actually accepting that challenge and keeping it as a question. It's an unresolved issue that usually when you have an unresolved issue in this kind of case, you go to you take the lenient way, and you're accepting what Rav Nachman is saying essentially, and that is the end of this section of the Gemara, which we started last time. Any questions before we start the next piece?
It's kind of strange with Rav Nachman objection, because in his description, both the witnesses, the conspiring witnesses, and the accused are subject to death penalty, right?
That's the Mishnah.
Saying that it's either one.
What's the question about him is from the Mishnah, not from what he's saying. I didn't understand what you were saying. Can you ask again?
In his narrative, right?
Yeah.
In his narrative, we've got the conspiring witnesses, right? And they're subject to death, right?
Right. That's not his narrative. That's not Rav Nachman's narrative.
It's Mishnah. He's pointing to the Mishnah, right?
Rav Zutra is pointing the Mishnah. Okay, yeah.
Rav Zutra. Okay. Sorry. Okay, and then we have another set of witnesses that condemn the accused.
Yes.
So he's subject to that as well. But we kind of were saying that either the witnesses or the accused are subject to death.
Both of them. Both of them are subject to death according to the Mishnah.
both of them.
Right.
Okay.
One because he did the crime and you have witnesses, and the other said because they're conspiring witnesses and they tried to frame him and they didn't have the right to do it. So, it's basically two different crimes.
Mm-hmm. I thought that we were saying that if before that it's either conspiring witnesses or then he goes free, right? But over here we have another couple of witnesses that he's
right. So if we would have had only one set of witnesses and they became conspiring witnesses, the accused is going to go free and they're going to die instead. But because you have another set, which is kosher witnesses, that nobody is objecting and nobody has anything against, and they basically testifying that the crime occurred that way. So you have to listen to them. They're not. It's not their fault that you have another set of crooks that came with a lie.
Okay. Thanks.
All right. The next thing in the Mishnah is the opinion of Rabbi Yossi. And we mentioned that we need witnesses in order to convict someone, right? And we need also someone who's going to warn, right? So Rabbi Yossi says that is one of the same, meaning that the warning has to be delivered by the witnesses. He's much more strict as to how the what qualifies witnesses as witnesses if they're the ones that delivered the warning, and if those are the ones, if they didn't deliver the warning, they cannot testify. I mean, they don't accept their testimony. Okay, so and he's saying that this is a fundamental condition in the in identifying a kosher witness. And so Amar le Rav Papa le Abaye, umi itle le Rabbi Yossi hai svara. So he says, hold on. Rav Papa is asking Abaye a question. You telling me that Rabbi Yossi, remember the name Rabbi Yossi, is saying that the witnesses has to be the ones who warn. But we have another Mishnah somewhere else later, three pages further in the Gemara, that says that Rabbi Yossi says something not so. Rabbi Yossi is saying, Rabbi Yossi Omer hasoneh neherag mipnei shu kemuad umutre. Rabbi Yossi says as follows in three pages. If there is a dispute between two people, okay, and one hates the other, and everybody knows that they hate the other. Every time they show up in shul, the guy screams at him and he admonishes him, and he just hates him. Everybody knows he hates him, and then he killed him. The person who is hating killed the other guy, and so Rabbi Yossi says in that case, you don't need a warning. You need the witnesses and all the other conditions, but the warning you don't need. Why? Because he is hating him, and it's a known fact. It's like a standing warning, because you're not allowed to hate another Jew, and it's not okay to go around hating people. So the fact that he is hating him and it's known, it's as if he was told already. You can't kill him. You can't kill a person just because you hate them. So because so what that means is that the warning is not really, according to the Mishnah ahead, is not really for the purpose of warning the person, because he is the warning exists already in another way. It's in order to make sure that the court understands that the person understood what he's doing. That the court understands that it was on purpose, that he was told not to do it and he did it. Not that the warning is qualifying the crime. The warning is making the judge knowing, is making the judge aware of the conditions that the murderer, what he had in mind, the intentions of the murderer, not the conditions of the crime, but the condition of the mind, the mindset of the murderer. So we see here that according to Rabbi Yossi, what we said here in our Mishnah, that Rabbi Yossi is requiring the witnesses to be those who are warning, because the warning is part of the procedure. You need to deliver the warning right before the crime, otherwise it's just like witnesses, it doesn't work. And here we see in the Mishnah in 3 pages ahead, we see that you don't need the warning in order to create the conditions for the crime. It's okay if there is no warning because the person hates someone, so there is a standing warning. It's only in order to identify in the eyes of the court if the crime happened on purpose or not. So Rabbi Yossi, what's going on here? So Rabbi Yossi cannot say those two things because they disagree with each other. So the Gemara is answering that there are 2 different Rabbi Yossis. Plain and simple. 2 different Rabbi Yossi. In one place is Rabbi Yossi Bar Yehuda, and another place is Rabbi Yossi Bar Chalafta. It's 2 different Yossis. And when we say usually in the Mishnah, Rabbi Yossi is Rabbi Yossi the son of Chalafta. That's usually what regular Rabbi Yossi is. And the Rabbi Yossi that in 3 pages ahead is not Rabbi Yossi Bar Chalafta, it's Rabbi Yossi Bar Yehuda. How do we know? Because there is right there, it will bring another braita in the name of Rabbi Yossi Bar Yehuda that says that חבר אין צריך התראה, לפי שלא ניתנה התראה, אלא להבחין בין שוגג למזיל. Rabbi Yossi ben Yehuda is saying that you have another exception when you do not need a warning. The first exception that we said in the Mishnah ahead is that the person hates someone and it's as if, he has a standing warning not to kill him because he hates him, right? There is another exception. If the murderer is a Talmid Chacham, is a knowledgeable person, is a scholar, is a Torah scholar, and as a Torah scholar, happens to be, he lost his mind, a big Rav in a yeshiva, take a gun and kill someone. And he knows the halacha. He teaches it. He gives a Gemara shiur on it every day. And he knows exactly what's going on. So a person like that, says Rabbi Yossi Bar Chalafta, doesn't need a warning because, and he's specifying why do we need the warning altogether. The warning is not in order to qualify as a condition of the procedure, of the process. The warning is just to enable us the understanding, to enable us to distinguish between someone who's doing something on purpose and someone who's doing it not on purpose. Okay, so it's basically to understand the judgment call that happened here. The person just he was playing with a gun and the bullet just flew, or he was aiming and shooting. So if there was a warning, that the person did it on purpose. And when you're talking about the Talmid Chacham knows better, and if he did something like that, that it's not a mistake. So that is the answer to the question. We have 2 competing opinions by Rabbi Yossi, except that it's 2 different Rabbi Yossi. Okay, the Mishnah continues. Any questions? All right. The Mishnah continues and teaches another snippet of law. דבר אחר, על פי 2 עדים שלא תהיה סנהדרין שומעת אם תהיה תורגמן. Very interesting. It says that the pasuk is saying in the Torah that when there is a crime that you need witnesses for, it says al pi 2 עדים, by the mouth. It's based on the mouth, from the mouth of the 2 witnesses. So the Mishnah is saying it's the 2 witnesses themselves have to express their testimony to the court, and the court cannot hear it secondhand, even if it's all standing in the same place, using a translator. So you have I don't know Mandarin, and I'm a judge in a court, and two witnesses are coming and saying the Chinese guys are giving a testimony that they saw a crime. I don't know Mandarin, so I need a translator. That's not good. I cannot accept that kind of a testimony because there is a lot of very important nuances that when you hear it directly and understand it directly, a lot of nuances that are getting lost in the translation. And it says the Torah is saying it has to be from the mouth of the witnesses. My knowledge as a dayan, as a judge, has to come from the mouth of the judge, of the witnesses, not from the mouth of a translator. So the Gemara is bringing a story, interesting story, that there was two foreigners, two gringos, who came in front of Rabbah, and they gave a testimony, and Rabbah put in between them a translator. He stood up a translator to stand up and translate between himself and those people. So how can he have done that? We have a Mishnah in our Mishnah that says that the court cannot hear from a translator. So the Gemara is saying what happens is Rabbah understood that language, but he couldn't communicate with this language. So he understood very well exactly what the witnesses were saying, but in order to communicate with them and ask them questions, he was not able to know. He didn't know the language that well, so he needed a translator for that purpose, to communicate to them and not for the other way around. All right? Now, the Gemara is bringing a story, and it's a story that's not related to what we just discussed, which is weird. It's related a little bit to something before. So the question is, why are we bringing this story here? So one of the answers is that this story happened exactly at the same time as the other story, when the two foreigners were standing in front of Rabbah. So the following story also occurred at the same time. So they're bringing the same stories together. And what is that story? The next story is Ilah veTuvia. You had two witnesses. One, his name was Ilah, and the other gentleman was named Tuvia. And they were witnesses testifying, giving a testimony about a loan. Okay? Now, the loan had three parties. The loan had Reuven, who was the borrower, and you had Shimon, who was the lender. Okay? So Reuven borrowed from Shimon. But you also had Levi as a guarantor. Okay? So in case Reuven doesn't have money to pay back to Shimon, Shimon can go and collect from Levi. Just a guarantee. So common practice even nowadays. So those two witnesses who are giving the testimony about the loan, they were relatives of Levi. They were relatives of the guarantor. Okay? So in the beginning, Rav Papa thought that because they are not relatives of the borrower and the lender, they're not relatives of Reuven and Shimon, and so they're considered not relatives, and therefore they would be kosher witnesses for that. So Amar le Ravuna Bered Rashu le Rav Papa. So Ravuna Bered Papa told him, listen, if the borrower does not have money, who will the lender go to? Who will go to the guarantor? So he's standing in the place of the borrower. So therefore, he they basically are conditional relatives to the borrower. In case if the condition takes place where Reuven doesn't have money, the borrower doesn't have money to repay, suddenly Levi, the guarantor, becomes the borrower, and then suddenly the condition is met, and they're relatives, and therefore they're not going to be able to testify. And that is and therefore they were disqualified. There is a little bit of a wrinkle here. I don't know if you're interested in a finger wrinkle. So there is, I'll say it anyway. There is some understand that what happened here is that when the two witnesses are coming to testify about the loan, they're actually giving two testimonies, two completely separate testimonies. Testimony number one is that Reuven borrowed money from Shimon. End of story. Testimony number two is that Levi is the guarantor to this transaction. So why don't we listen to the testimony, to the first testimony? That's what some of the rabbis, some of the commentaries are asking. We should, you should accept one testimony, but not the second testimony. So there are those who are saying that the story is a little bit more complicated, that the fact that Reuven borrowed from Shimon, we know independently. And the fact that Levi is the guarantor, we also know independently from a long time ago. The question here was whether Reuven paid or not. And that was the court case. Did Reuven actually pay back the loan to Shimon and then and the transaction is closed? Or the transaction is still open and Levi now has to be, Shimon can come and collect from Levi, from the guarantor. And they came to testify that they were there and they saw that Levi that they saw that he was paid or he wasn't paid. They were about to give testimony about the payment. And for that testimony, because their testimony will basically render their relative either off the hook or on the hook, they were disqualified from being witnesses. So it's more direct. They're really witnesses that are relatives to the actual cause, to the actual event that's happening here, and not just a side note. Anyway, it's an interesting conversation. All right, that's the end of this Mishnah, and then we're going to go to the next Mishnah, which will take us to the end of the chapter. Probably not today, but next time we will finish the chapter. So we should do a mini siyum on one out of 3 chapters. All right. The next Mishnah is also adding some rules regarding the procedure of the court case, and it's talking about someone who ran away. They were convicted in court, and then before the court was able to carry on the punishment, the accuser took off. Houdini took off and disappeared. So mi shenigmar dino vebarach. So someone that got a verdict to die, and before he was executed, he ran away. Uba lifnei oto beit din. And however, a few days later, he shows up in Beis Din back. He shows up or brought back to the same Beis Din, to the same court that rendered the verdict before. So en sotrim medino. So that court, those judges don't need to reopen the case and to start talking about it again and hear witnesses again. They are relying on the verdict that they themselves gave earlier, and they have the right, and actually they have the obligation to immediately execute the person based on the original verdict. And we will see later that there are exceptions to it. Another in the Gemara, we'll talk about it at length. Not at length, but we'll mention something. Anyway, kol makom, a second rule about an accuser who ran away, or a convict who ran away. Kol makom sheyamdu shnayim v'yomru מעידים אנו באיש פלוני שנגמר דינו בבית דינו של פלוני ופלוני פלוני על ידיו, הרי זה ירא. What happens if two people are showing to court and are giving a testimony and saying that we are testifying herein that Mr. So-and-so, John Doe, not John Doe, Mr. John Smith, someone that they know, he was, we were present in a court case. He was accused in a certain court somewhere else, and Mr. X and Mr. Y were his witnesses, and they saw the actual event, and he was convicted. Based on that type of a testimony, the court that just have these two witnesses that are telling him the whole story, the court is accepting that testimony, and they can actually execute the accuser based on their testimony, which is, I guess, I don't know if does it happen now. So now, there are some of the commentators are mentioning why do the witnesses who are coming to court and saying that we saw that other, we saw the court case and Mr. X and Mr. Y were the witnesses. Why do they need to mention that Mr. X and Mr. Y were the witnesses? Any ideas? So the commentaries are saying is that this is an opening for the witnesses that are coming here to testify that they saw the case to become conspiring witnesses. By mentioning the other set of witnesses, there is an opening to make them conspiring witnesses, because they can say, you weren't there, you weren't here, you didn't see them, you couldn't have seen them, they were with us, you were with us. So we are trying to sort of trip them. We're trying to figure out a way out, because we're not eager, the courts are not eager to go kill a person. So if someone comes and says, yeah, this person was convicted and he was sentenced to death. Hold on, give me a little bit more details. Were there witnesses? Which witnesses? What were the names? What did they say? So we're trying to figure out a way out. So the witnesses that are telling us the story will not be accurate, either because they don't remember or for whatever reason, and we want the court here will not have to kill that person. So that's number one. Number two, there is a, I'm just wondering, where did I see it? 1 second. It's 1 second. I think it's later. All right, whatever. That's fine. Let's move on. So that's one thing that the Mishnah. The second thing that the Mishnah is telling us about someone who ran away. A third law is Sanhedrin noeget ba'aretz u'b'chutz la'aretz. Okay. Who is qualified to sit in a court case in a capital punishment? So the Mishnah is telling us, we know from other Masech, from Masechet Sanhedrin, that the person must be, the court must be a large court. It needs, 1 second. It needs to be a large court. It needs to be a court of at least 23 people. You have three types of courts in Jewish law. You have the court of the Supreme Court, which is 70, right? 72. Forgot. It's I think it's 70. The court of in Beit HaMikdash, it's the Supreme Court, and that's the Sanhedrin Agadol. And then you have a small Sanhedrin. You have a court of 23 people, and they are not necessarily sitting in Beit HaMikdash, in the Supreme Court quarters. They can sit anywhere in any city, and they are allowed to judge a capital punishment. And then you have courts of 3 people, which is what we know nowadays. Those courts of 3 people who can judge monetary and other laws. Nowadays, Jewish law is such that there are no capital punishment. Why? Why our judges today cannot render a death sentence in a Jewish court? Because the Beis Din, the big Beis Din in Yerushalayim, is not sitting there. Not only that he's not sitting there, it doesn't exist. Now, what happens is, the law is that if there is no Sanhedrin, if there is no Supreme Court in Yerushalayim, in the Supreme Court quarters, you cannot. They have to be in the actual building of the Supreme Court, which was adjacent to Beit HaMikdash. It was on the I think on the northern side of Beit HaMikdash. If they are not there in court, in session, you cannot run you cannot listen, you cannot hear a capital punishment case. Now, at the end of the second temple, the end of the second temple, there was a crime wave in the land of Israel. And you had a lot of murderers. It was chaos. You had a lot of people, from the outside, foreigners are trying to tear apart the country. Sancherib and others took pieces. And there was chaos. There was total chaos. And that gave opening to a lot of murders. So 71 members. Thank you, Moshe. Somehow I drew blank for a second. So what happened is, 40 years before the destruction of the Second Temple, the rabbis determined that the situation in the country is such that there will be a lot of capital punishments, and they just didn't want to deal with it. They didn't want to deal with it because there were some of them were afraid that they're going to be, retaliated against. When you have crime families and you try to, you put one to death, you have another 30 that come after you or your wife. So it was a case where they couldn't afford and they couldn't run capital punishment. They couldn't hear capital punishment. Now, the law is that if you have a Beis Din in the Supreme Court and a capital punishment case comes about, you have to hear it. You can't say, I don't want to, I'm afraid of the mafia. You can't say that in Jewish law. So what did they do? They used this clause that you must have the Supreme Court in the Sanhedrin, in the chambers, in order to hear capital punishment, and they basically moved the Supreme Court outside of the Beit HaMikdash. Some say outside of Beit HaMikdash, some say outside of Yerushalayim altogether, and they were basically holding all of the other sessions of the Supreme Court, but outside of Beit HaMikdash, which gave them the ability to sit on any other case except capital punishment. Okay? Now, so what the Mishnah here is saying, that if you have a Sanhedrin sitting in Beit HaMikdash, then you can rule capital punishments all around Israel and outside of Israel as well. Here's another thing. In order to be qualified as a judge that is allowed to sit on a capital punishment, you have to be a Rav. You have smiche. You have to receive smiche from the Supreme Court, from the Sanhedrin, and they got it from their Rebbes, and from their Rebbes till Moshe Rabbeinu. It needs to be musmach. We need to have the chain of smiche, the chain of ordination up to Moshe Rabbeinu. But if you have such judges, which at the end of the Second Temple you had a lot of judges that passed the bar and were able to be judges, right? And then 23 of them ended up outside of Israel, like what happened during exile, right? 40 years happened, and then during that time, you had several shifts of exiles going to Bavel, and 23 of them who were qualified to sit in such a case were sitting in Bavel. As long as the Supreme Court in Israel was sitting in the chambers in Beit HaMikdash, they can sit and hear cases of capital punishment even outside of Israel. So that is a third law. And the fourth law is, we're saying Sanhedrin that is killing, ended up executing one person in 7 years. They're called Chovlanit. They're called a destructive tribunal, because we try, it's not good when you ended up actually killing someone. And Rab Lezer says even more so if it's a court that kills once in 70 years is rendered a destructive tribunal. Now Rabbi Tarfon and Rabbi Akiva, who lived at the time of the destruction of the Second Temple, okay, and so they became part of the Sanhedrin, became of the Supreme Court during that 40 years that the Supreme Court was outside of Israel. So during their tenure, the Supreme Court never heard a capital punishment case. Rabbi Akiva and Rabbi Tarfon were saying, had we been in a Sanhedrin, in a Supreme Court that was sitting in Beit HaMikdash and would hear capital punishment, we would make, on our watch, nobody would have died. And we will see in the Gemara what exactly is the construct. How can they be able to make sure that no one would die on their watch? And Rav Shimon Gamliel, however, disagrees with them and say, listen, you yourself are causing death, because by not punishing someone who needs to be punished, you are removing all of deterrent. You're destroying the deterrence. And other people will say, I can get scot-free because Rabbi Akiva and Rabbi Tarfon will never kill me. So therefore, I can go kill, willy-nilly without being punished. So Rabbi Shimon Gamliel, who was more of he was the head of the Jewish people at the time. He was from the house of Bet Shammai. He was a more strict guy, and he said, no. They doing that and not killing someone who deserves to die is causing more death to innocent people. That's the end of the Mishnah. We'll expand on it next time in the Gemara.